Thank you, Michael, very much. Not many people have read the book yet, so it's been out almost 2 years. Still waiting for reviews and welcome comments. So there are a lot of questions that even I, as author, am unable to answer, even after thinking about this for about 12 years. What precipitated the recording of these court decisions is itself something of a conundrum. We have no explicit indication either in anything that the Beit-Din wrote or in anything surrounding it that would give us an absolutely clear clue on that. My sense is that increasingly there was intrusiveness on the part of the secular authorities, the government authorities, and that there was a need for the rabbinical authorities, the communal authorities, to have records that they could point to as an indication that they were keeping track of the litigation in their communities, even though this was clearly not accessible linguistically to the secular authorities. But be that as it may, let me go directly to the last point you made about why there is no evidence of precedent in these cases. First of all, precedent itself is only a tortured question regarding law. Second, and more directly, you've suggested that perhaps the Beit-Din did not understand secular law very well, and therefore it didn't want to rely on previous decisions that it had made, simply because it was ever changing. Their own understanding was unstable. So the fact is that there are cases where they're not relying on or pointing to secular law, and those decisions are also not the basis of precedent. So I think that the problem is larger than what you suggested. And is there something more intrinsic to the culture of Bate-Din that would explain the phenomenon? I'll put that out as a question. Beside that, I'll just mention one other small point, which is the question of forum shopping. Why would anyone go to the Beit-Din if there was a possibility of adjudicating and possibly achieving better results in the French civil courts? And we're talking about the decades prior to the French Revolution. And I think there are a couple of clear reasons for that. First of all, there was still relative peer pressure, strong peer pressure in the 2 decades prior to the collapse of judicial autonomy or communal autonomy in France prior to the French Revolution. So even though that peer pressure is no guarantee that people will line up at the Beit-Din, is a factor. Second, there is greater efficiency in judgment. That is, the Bate-Din produce a legal decision more quickly than do the French civil courts. And third, there's an economic reason, which is that the court costs in the Beit-Din are much lower than they are in the French courts. So these things, I think, add up to a preference on the part of many. But I think that at the same time, what I discovered in the course of my research was that one of the reasons why Jews are going so regularly to the civil courts and not adjudicating 100% in the Beit-Din is because their own economic involvements are so incredibly complex. And there are so many instances where there are collaborations, partnerships, entrepreneurial cooperation between themselves and Gentiles, that there might be an inheritance case that is still waiting to be resolved because of some money that's owed to one of the partners by a non-Jew, and he's gone bankrupt or whatever, and that has to be ruled in the French civil courts, and only then can. And there are reasons why Jews got comfortable also litigating among themselves, even when they could have litigated in the Bate-Din. So I think it's a complex set of questions. My job until now has pretty much been to try and record and provide first impression analysis, first impression based on 10 years of research, and and hoping that it will, at the very least, inspire some additional work in this area. There's many questions, not as many answers, but I suppose that's what scholarship is all about.